morning, everyone. Welcome to today's webinar. My name is Joe Anderson, Certified Financial Planner, President of Pure Financial Advisors. Doing something a little different today. Doing the webinar here at our TV studio. And I have my good friend Nicole Newman. And she's basically going to go through the 10 gruesome estate planning mistakes that you never ever want to make. Welcome to the webinar. We're going to have question and answers, so if you do have any of those, you can just call in at the end of the show, and we'll make sure that we get any answer or any question answered to you ASAP. So without further ado, I want to welcome Nicole Newman. Hello, Nicole.
Hello.
How are you?
I'm doing quite well, thank you.
Yeah, we got bright lights here for you.
Absolutely.
Very excited?
I'm very excited, yes.
Well, let's dive in. Let's talk about the biggest mistakes or gruesome mistakes. Mistake number one.
Yeah, so mistake number one that I see most often coming through my office is when somebody has died intestate. And that simply is the legal term that they died and they absolutely did nothing to plan for their death. So it's not them coming through my office, it's their children coming through. The big problem is when you die and you failed to plan for your death, the state of California has a backup plan for you, and that's done in the probate court. The reason we want to avoid probate here in California is because we have the longest and most expensive probate process in the entire country. By long, I mean a year, year and a half. And by expensive, I mean it comes out to about 5% of the gross estate for the costs.
What is an I love you will?
So an I love you will, that is also a gruesome mistake that we tend to see come through our office, and that is folks that died and the only thing that they did to plan for their death was executing a will. So people who die with a will, they're only one tiny little step above people that did absolutely nothing to plan for their death. And the reason why they're a little step above is because at least in their will, they chose who their beneficiaries are. When you die intestate, the state of California picks your beneficiaries. When you have a will, you get to pick them, but you're still going to go through the probate process. And again, you're going through that long, expensive process here in California.
Well, a lot of times people will try to put things joint ownership to avoid the whole probate process, right? Let's just put kids on title, you know, or hey, I'm not married, so I'm going to put my brother on title of my overall property. I mean, that's not necessarily the proper way to do this either, is it?
No, exactly. And that is a very common way that we will see folks trying to avoid probate is adding their children on jointly. There's the problems of adding them on jointly on accounts, but putting them jointly on real estate. The big problem when you put your child on the real estate, then any legal issues that your child might run into, your property is going to get pulled into it. The other issue is the tax implications. So if you hold title as joint tenancy with your child, when you transfer the property over to the child, there's going to be some gift tax issues there. And then the other issue is when spouses own their property jointly. When spouses own their property jointly, then the surviving spouse is not going to get a full step up in the tax basis when the first spouse dies.
Yeah, let's dive into that because that's a huge mistake where I think people really don't understand. It's like, all right, let's say we were married and then we had a house, it's owned jointly. Yes. And then all of a sudden I were to pass and then it's only a half step up. But if we're in a community property state of California, does that still exist?
Well, the issue is the state of California is a community property state. So the state of California will respect the community property nature of an asset that is titled as joint tenancy. However, the IRS looks at title. So the IRS is going to look at title, so we do not recommend for married couples to own the property as joint tenancy. Obviously, our recommendation is to own the property in a trust, but if you don't have a trust yet, then the ideal is to own the property as community property with right of survivorship.
What about the issue of, you know what, I'm just going to give all my stuff outright to the children?
Yeah, so the problem with transferring your assets during life, which is another technique that people will use to avoid probate, and the problem is, again, back to the tax issues. So when you pass your assets to your children through a trust, when they inherit those assets, they're going to receive a full step up in the tax basis on most of those assets. When you transfer those assets to your kids while you're alive, they will take your tax basis in the property. So this is a big one that we see here in Southern California when we have people that they purchased their properties decades ago for much less than what they owe now. If they transfer that property to their children during their life, when their children go to liquidate that property, there's going to be a big capital gain. Whereas if they wait till they have passed away, then their children will receive a full step up in the tax basis to the date of death value.
You know, I think sometimes people try to avoid estate planning tax, they're like, well, we have an estate tax. They don't have an estate tax issue. And so they bought this house for $100,000. It's worth, let's say, $1 million now, right?
Yes.
And then they just give it outright to the child and say, well, let's just put you on title so we can avoid that. Well, there's not going to be an estate tax, and then it just caused a huge tax. Another problem or issue here is that if you just give, let's say, in your estate planning outright without any other language, so there's, you've got some funny stories when it comes to looking at how it goes to the next generation, making sure that you have some documentation there so you really know where your money's going to go.
Exactly. So another issue that we will see are people that they are trying to give their assets outright to their children, some that try or they accidentally do it. So outright distributions, that's where when you pass away, your assets just go to your children outright into their own name. They can go do whatever they want with the asset. We'll see this done when people have died intestate. That's the default, is an outright distribution. When people have a will, usually the default is going to be an outright distribution, or when people have a trust with outright distributions in the trust. So that's just where they said, when we both die, or if they're single when I die, the assets just go to my children outright and free of trust. Or if they did their trust back when their kids were younger, they probably did the old stages where they said it's held in trust for the child. When the child reaches age 25, they get a third. At age 30, they get another third. And age 35, they get it all. So that's essentially an outright distribution. Well, the problem with outright distributions are certain beneficiaries.
Like Frankie?
Absolutely, like our son Frankie.
Frankie.
Yes. So
watch out.
Yeah, Frankies, and there's a lot of Frankies lurking in a lot of families, whether people want to admit it or not. And Frankie is our child that just hasn't quite grown up in life. And at his age, it's not looking like he's ever going to be quite motivated by life. And Frankie's just unable to handle his own financial affairs. In fact, the parents are usually probably still taking care of Frankie. Well, if this type of a beneficiary were to receive an inheritance outright, to suddenly receive the entire estate outright or a portion thereof, they are going to blow through that very quickly. They're going to be unable to manage it. They say the average time it takes a beneficiary to blow through an inheritance is 18 months.
18 months.
18 months.
So it looks like Frankie is going to eat his inheritance here.
Absolutely. Frankie is going to potentially eat his inheritance, because I was going to say...
He's got a little nacho cheese right there on his, on his shirt.
I was going to say, they say 18 months, but I can tell you from personal experience of administering many estates, it's actually a matter of months. That Frankies have the abilities to blow through that money without, with nothing to show for it, and to do it very quickly.
What about Marvin? Let's talk about your boy Marvin. Are you sure you want to give your life's work to him?
Exactly. So Marvin is our son that's the polar opposite of Frankie. He's our son that has been too motivated by life. So Marvin's got out there. He has got himself in a lot of bad business deals. He's got creditors after him. He's got the IRS after him. The parents have probably bailed him out many times. Well, if you die and leave your assets outright to a Marvin, and he has creditors or judgments against him, they're going to be able to intercept and attach his inheritance. So we do not usually advise to leave outright distributions to this type of a beneficiary.
What about the next one? How about Teddy?
Okay, so Ted is our son-in-law.
Yeah, he's a little Southern California kid there.
Ted is our son-in-law, and our son-in-laws can become a problem, and our daughter-in-laws too, but we're just going to stick focusing on picking on our son-in-laws. So people will come in, and I try to encourage them to be honest with me about how they feel about who their child married. And some people will say, oh, I absolutely love him, or I absolutely hate him, he's a deadbeat. But either way, I would not want him to inherit our assets. Well, if you pass away and you have left your daughter her inheritance outright, and she's married to Ted here and has kids, well, if she dies first, those assets are most likely going over here to Ted, not down to the grandchildren. So if you absolutely would not want that to happen, then you would not want to leave an outright distribution to your daughter.
So how do you title that?
Okay, so
so let's say, well, let me ask you two questions.
Yes.
So we have the daughter married Teddy. Mm-hmm. Okay, we don't care for Ted. Right. We love the daughter. Mm-hmm. Grandkids now. And so let's say if the daughter's still alive, she inherits it, but then if she were to pass, then it would just go to Ted. Would we just advise her to keep it in separate property, then it would go to the grandchildren versus Ted, or could you do that, or how does that work?
Well, you could advise her and hope for the best, but
There's no documentation that you could guarantee that.
There's no documentation that you can guarantee that. And usually when married couples go in to do their estate plan, 99% of the people that I ask, okay, when the first spouse dies, where do you want your assets to go? And 99% of those people are going to say, oh, everything to the spouse first. Well, even if she kept it as separate property and she dies, it's still going to go over to Ted. So this is how we see a lot of grandkids disinherited.
Well, so I guess son-in-laws, we can't just blow them up. There's daughter-in-laws too.
There's daughter-in-laws, and there's a lot of, even when they're great.
Right.
Even when we love our son-in-laws, it's a problem, because if you die and everything goes out right to your daughter, and even if we love our son-in-laws, well, if he turned around and got remarried and then died or divorced, then the money is going sideways. So that's why I typically do not recommend outright distributions to beneficiaries, even when we have a responsible beneficiary.
And then you have like blended marriages, right? Where you have maybe a child from a previous marriage and then you remarry and then you have children together, and then there's this issue, I guess, or complications that could arise there.
Yes, absolutely. So folks who are in a blended marriage situation, they're on their second, third, or fourth marriage, they absolutely need to get an estate plan put in order and get the rules laid out while they're both alive, because the children from the prior marriage are either A, going to give you the spouse a difficult time, your spouse is going to give your children a difficult time, or even if we have a Brady Bunch situation, there might be an accidental disinheritance unless you legally adopt your spouse's children, which usually does not happen. So we'll find if you and your spouse went your lives without failing to do any planning, one of you dies, the other one continues to fail to plan, and then that spouse dies, well, guess where everything's going? To that spouse's heirs, to that spouse's children, not to your heirs. So it's a big problem.
Say that again. So I remarried.
Yes.
They have children. I die. Everything's going to go now to my wife, right?
Yes. Mm-hmm.
And then I have a child from, let's say, a previous marriage.
Yes.
So then when she dies, the likelihood of she giving anything to my child from a previous marriage could be zero.
It could be zero.
Right. And then she's going to give it to her children.
Yeah,
potentially.
Either she's going to intentionally do that, or the
But
law,
I'm in your
or the
office.
law is going to do it for her. Because let's say she loves your child,
Right.
and she just goes along like a lot of us do. Well, I'm going to get a plan in order. She would have to proactively plan and know that she needs to proactively plan to actually leave anything to your child.
So if she has no documentation,
If she has
right,
no
it's going
documentation,
to go to
the
her
law
kids.
is going to give it to her children. So she might go to her grave not even realizing that
Exactly.
she disinherited your child. So that's what I'm saying. Even people with the best intentions can end up disinheriting beneficiaries.
That's probably more common than not.
It's very common. Yes, it's absolutely common.
And that's something that you probably would never think of.
No.
Right?
Nope.
It's like, you got the Brady Bunch. I think they all
Yes.
loved each other.
Yes.
Right? But then, things happen in life where, all right, well, one spouse passes, then it goes because unless they legally adopt, is that what you?
Exactly, yes.
But if let's say the child's 20 years old, I'm not necessarily going to legally adopt. Right?
Exactly. Mm-hmm.
So.
Yes.
Give me another one. You got another story or two, don't you?
Yes. So probably the one that strikes fear in most hearts, especially here in Southern California, is the thought of, well, if I die first, is my spouse going to get remarried and then leave all the assets to the new spouse rather than to our children, either get tricked into leaving it to a new spouse, either intentionally or unintentionally. So that worries a lot of folks. Well, if you're married and you die first and you and your spouse failed to plan, and let's say he turns around and gets remarried and he continues to fail to plan, Elaine here could most likely end up with all of the assets.
So Elaine's coming over to the house.
Elaine,
right,
yes.
with a bottle of wine, right, little pot roast.
Yep,
right?
yes, yeah.
Couple weeks after.
Yes.
I understand.
And the husband's enjoying being pampered again and wants his laundry done, so she could either get him to change the plan, or just the law could end up leaving it to her.
So a lot of this is that things that could happen, but unintentionally,
Yes.
right? Because it's like, all right, well, I love my spouse. When I pass away, of course, I'm not going to see Elaine. She's not going to be coming over with wine.
Right.
I think a lot of times people will look at, all right, well, I want to protect it from maybe the government or Congress, right? That they're going to take. I think that has a little bit more realistic feeling, but all of these others probably will happen, more likely than Congress, or maybe not.
Well, the problem with Congress is just
Well, there's a
how
lot.
often they change the law.
Sure.
And the other problem that we see is I think a lot of people don't understand how complicated dying has become and how involved the government has become in dying. So it's definitely prudent that we educate ourselves and that we make sure we have structured our affairs after we pass to not unintentionally be leaving it to the government.
Well, you know, you take a look today, right? We have a new president, and then there's some talk about, you know, tax reform. We'll see if that goes through.
Yep.
And then, all right, well, maybe the estate tax will be abolished, but that still doesn't fix anything else.
No, it's one tiny little aspect.
Right, and I think that might, I guess, discourage someone or may not have them do the right planning because there's no estate tax, so well, I don't need a trust. I don't need to hire an attorney to do this.
Yes.
Everything will be fine.
Yes.
And I hopefully we're proving this today that there's definitely a lot of things. What are some other options that people can do here?
Okay, so as you've heard me say multiple times now, I do not recommend leaving assets outright to the examples that we just gave, but in most cases, I recommend not leaving assets outright. Now, for spouses, if we do have a spouse that is worried about if they die first that the spouse is going to leave assets to a new spouse, that is something that I talk privately one-on-one with folks to show them their different options there. But as far as for the children or for our ultimate beneficiaries, I recommend that they leave their assets in trust for the beneficiary, even when the beneficiary is responsible. So that way you can, one, provide some asset protection for the beneficiary, because if you die and the assets go outright to the beneficiary, those assets are exposed to the beneficiary's creditors, the beneficiary's spouse if they end up divorced, and then of course not being able to get the assets to the grandchildren.
All right, so we have a child die, the child inherits it. You want them to hold those assets still in trust.
Yes.
So then that would be totally separate in a sense. Is there other complications that they would have to do if they held those assets in trust? Because now it wouldn't be joint with their spouse. It'd be a totally separate property trust.
Yes.
And would the parents still be, so what would the titling look like? How would that work?
Okay, so the way that it works is simply in the trust, when it gets to the parts of the distribution for the children, instead of saying outright and free of trust to my children, the trust is then going to lay out the rules for the trust that is going to be then created for the child. Now, within the terms of that trust, and the parent is the one making those rules while they're alive, and we're spelling out those rules in the trust. Now, they can pull the reins as tight as they want or keep the reins as loose as they want. So if we have a Frankie or a Marvin, so a proven financially irresponsible child, we're going to pull the reins tight. That means they will never be their own trustee. There will always be someone else managing the money, so they're unable to blow through it. Now, if we do have a responsible child, we still would want to leave it to them in an asset protection trust, because we don't know what the financial situation of the child's going to be when the parent dies.
So tell me this, then what is the right trust?
Well, it's an asset protection trust within the original trust. So it's simply saying that the assets go in trust for the child, and that trust will last for the lifetime of the child. Now, if we have a responsible child, we allow that child to be their own trustee.
Got it.
So they're in full control.
Right.
If we have an irresponsible child, then we have someone else serve as a trustee. And since that trust is lasting for the lifetime of the child, then we get to choose what happens to the assets once the child dies. So we can say the assets are going to be held in trust for the benefit of my child while he or she is alive, and then when he or she dies, it has to go to their children if they have any. And if they don't have any children, it goes to the other siblings. So this is how we keep the money in the family line, and we can make sure that our grandkids are actually going to inherit something.
So then here's another one is that, all right, well, I'm convinced I need a trust. I don't want Frankie or Marvin or Katie or Elaine to mess with my stuff, right?
Yep.
And so I figured out the right trust. So I established the trust, and then I don't fund it.
Yes, so this is a huge mistake that we see people make. And this is they actually create their trust, but then they never put their assets into the trust. And that's a very important second step. So when you create your trust, you need to properly move all the assets over, and the legal term for that is called funding your trust. Now, it does not mean all of the assets are going to go into the trust. So there's going to be some assets that will be left out, and there's going to be some assets that cannot go into the trust. But overall, we're giving you kind of an overall of what should go into the trust. Typically, yes, the brokerage account should be retitled in the name of the trust, bank accounts, any business interest if it's allowed by the operating or bylaws, shareholder agreements.
And then, well, how often would someone need to update their trust?
About every 3 years. Let me correct that. At least review their trust every 3 years. In my office, it's standard that we review our client's trust every 3 years.
Just in case, but if something's changed significantly in someone's household, you probably want to make, if I have a new grandchild, a new child, or whatever, then you probably want to take a look at that. But if there's no massive changes, then every 3 years is still a good idea?
Yes, every 3 years. Every 3 years is, I find it's a good point to take a look at the trust, to remind people this is what you said 3 years ago. Have we had any major life changes? And it helps people to make decisions. Because one of the big things that I find that prevents people from actually doing their trust is they struggle to make decisions.
Right.
And because they're trying to project too far down. I tell people, what would work if you were to die in the next 3 years? Because some people try to project too far down, so it makes them unable to make decisions, or they end up with a 130-page trust because they have so many contingencies. But really what I'm doing in those 3-year reviews is we're taking a look at their assets, because our office keeps an asset spreadsheet of our clients, and we look at the asset spreadsheet to say, hey, in the past 3 years, did you acquire any new assets?
Right.
And forget to put it in the name of the trust.
So this is another good reason probably why you don't want to do this yourself?
Exactly, yes, yeah. So another big mistake that we see, or I shouldn't say, well, are people doing it themselves, but it's probably the most common question that I get asked. Or I'll have people say, Nicole, you're really great, but those LegalZoom prices are even better.
Right.
So why should I use LegalZoom instead of you? Well,
I think with anything, with this something this important, I don't even want to talk about LegalZoom, right? Because you should absolutely hire a qualified professional to help you with this in a sense, right? And so taking a look, the trust is only one thing, but then believing that the trust is just it, right? There's a lot more things that someone has to do.
Absolutely. So you would never just have a trust alone. So the trust is just one component of what makes up your estate plan. So the trust has several supporting documents that go along with it. For instance, you're going to want to have an advanced health care directive. And here in California, you're going to want to have a separate standalone HIPAA authorization. These documents are where you're going to name someone to make medical decisions for you if you became unable. And then the HIPAA authorization is going to allow the people that you have named to be able to review and communicate about your medical records as well, because not even spouses are entitled to each other's medical records.
Right, that's craziness.
Yes, yes. And usually people are finding this out in an emergency type situation. So we want to have these documents prepared ahead of time. Plus, you just don't want to leave your loved ones guessing what you would want to have happen when you are no longer able to communicate. It's a very stressful situation for your family, and you want to leave some guidance, leave them some directive behind of what are your decisions. You're also going to want to have a power of attorney. So this is where you are naming someone to handle your finances for you in the event that you're incapacitated. This is a very overlooked area where people focus on their death when they're doing their estate planning, but they don't stop to think about, well, what should happen if they became incapacitated, which is more likely to happen before they die. So we want to make sure that we have the documents in place that your wishes can be communicated financially if in the event of incapacitation.
I mean, I think that is probably one of the most overlooked documents too.
Yes.
Do you have an estate plan? Sure, we have a trust. Well, do you have a financial power of attorney? Well, I don't know.
Right.
Or do you have a healthcare directive?
Right.
Well, maybe. I think I might have set that up.
Yes.
Because when when death is a little bit easier. I mean, not necessarily emotionally, right? But okay, well, it's joint. We can do this. Beneficiary designations. All right, one spouse is still alive. But when one spouse is in a coma because of a car accident, and all the money is in that person's retirement account, they got to pay the bills, or they got to figure out what did the spouse really want. Do I pull? Right, remember Terry Schiavo?
Yes.
Remember that craziness? It's like, no, her parents wanted to keep, and then he's like, well, no, it's my wife. It's draining. I mean, you don't want any of that. And so, I mean, let's say I'm coming to your office. How fast is it going to be? Because I don't want to deal with this. It's always tomorrow, right? Procrastination is the biggest thing.
Exactly.
So you put together an estate plan. How much pain is it going to be?
It's actually, we make it pretty painless for people. We break it down, we make it a very easy process, very straightforward, do not use legal mumbo jumbo, and we usually break it down over to about 3 small meetings. So we try to break down the meetings to smaller meetings so people aren't so overwhelmed, because it can be a heavy topic for some people and it can be confusing. So we break it down in a very systematized manner over about 3 meetings for most of our clients.
And what is the last gruesome mistake?
Well, the last gruesome mistake is procrastination, is we are our own enemy. So the people, we always put it on our list that we're going to get it taken care of, and we just don't, because it's an intangible benefit and it's not a pleasant topic for most people. They don't want to think about what would happen if they were to pass away, or they're not ready to talk about their death. But yeah, the biggest mistake that we do see in the office is procrastination.
It's craziness.
Yes.
You know, one of our camera people, she's like, you know what? I need to get my trust done.
Yes.
Right? The floor director. You got your trust, right? The producers. I'm getting in my ear. Nope, I don't got one either.
Yeah.
Nope. Get your stuff together, people. Come on.
Like,
we're not going to live forever. We're not going to live forever. Hey, if you have any questions, please feel free to email us at info@purefinancial.com. We'll take any question that you have. We'll answer it. Hopefully you enjoyed this kind of fun little session that we had with Nicole. I want to thank Nicole Newman, and it was a lot of fun having her on. And so let me know what you thought. We'll come back to you with more great information. Have a great day, everyone.